This is a public defender case, but I don't know who's assigned.
Rob Down, assistant prosecuting attorney, on behalf of the.
Where's here?
Yeah, the substitution is being emailed to me.
Substitution. Okay.
Oh, the subs
The substitution matter is being emailed.
right now.
Yeah.
Okay, go ahead.
Good morning, Your Honor. Jordan Goldberg, P87047. I'm standing in for newly substituted counsel Nicholas Somberg on behalf of Ms. Duplessis.
You have no objection to that, ma'am?
No.
All right. What are we doing?
Your Honor, we would ask that you set it for an exam. I have Mr. Somberg's calendar.
Is all discovery complete?
He has received discovery. He is still reviewing it, but he is ready to go for an exam.
I understand.
Today's courtroom session covers two very different cases, one involving strict bond conditions and a defendant struggling just to see her children, and another dealing with eviction and thousands in unpaid rent. Watch how the judge balances compassion, law, and reality in real time, and decide for yourself who deserves more leniency.
What you're saying to me. My question is all discovery complete?
I believe so, Your Honor.
I don't know. People have their witnesses available the third.
Your Honor, I'm actually in trial that week with Judge Movie.
Any objection to going beyond that date, counsel?
No, Your Honor. We would waive 21 days.
The 10th? Will that work for the people?
Yes, sir.
Yes, Your Honor.
Preliminary examination in person, February 10th, 2026, 9 a.m. That's before Judge Freshout.
And I do have one bond issue I'd like to address.
Go ahead.
Your Honor, my client has no felony criminal history. I understand the charges in this case are serious. She has been ordered not to have contact, obviously, with either complaining witness, but she's also ordered not to have contact with children of any kind. She's been ordered not to return to her own house, where one of the complaining witnesses previously resided and no longer resides. As a result, she's been living out of her car. She's been driving 2 hours from Clinton to Adrian to work every day. Your Honor, I'd be asked that you modify bond to permit her to have supervised time with her 3 children separate from the complaining witness in this case, and also return to her home in Clinton. Her husband, who is the father of her 3 children, separate and completely unrelated to this case, is present. He would be present for any supervised time with the children, who, again, are not complaining witnesses in this case. I believe the bond condition that she not have contact with any of her children at all is overbroad and unreasonable.
Your Honor, I was at the arraignment. It was supervised visit to be supervised by Lenawee County CPS.
That's already been ordered.
Yeah.
That's what I see.
Then the only outstanding matter would be permitting her to return to her home. It was previously listed as the home of one of the complaining witnesses. None of them stay there anymore. The people who live there are her 3 children and her husband, her 3 children who are not related.
Who is Khalil Harvey?
I believe that is the,
That is one of the,
That's
I know, but who is that to this defendant?
an ex and a child of her father. He is one of the complaining witnesses.
she indicated in the arraignment that she was living on Carriage Avenue in Canton, Michigan. Is that not true?
That's where I had to stay.
I believe that's where she was sleeping during the arraignment, but that has since changed.
And I don't think the victim or the child is in Clinton, so I don't have an objection.
They what?
They're not in Clinton. The address in Clinton.
Must have address.
They're with the father, the other 2 children who are not involved in the case.
I don't have, that's not the prohibited address I have in Clinton.
You know, how about this?
I have a prohibited address of Ann Arbor, on Ann Arbor Trail. And then Post Oak Drive. Okay, that one I see. Post Oak Drive, they didn't list the town. So those are the 2 that I have.
Right.
If
We could do a stipulation if you want.
I think you need to, because I don't know what
we're asking she be allowed to return to Post Oak Drive.
I understand what you said, but you're not giving me all of the information regarding who's there, who's not there.
Yeah, I can put it in a written motion if that's preferable.
Why don't you try this? Why don't you call Mr. Duarte, talk to him, and then see if you can stipulate. If you can't stipulate, then I'll be happy to hear your motion.
Happy to do that, Your Honor. Thank you so much.
Bond is continued. Motion at this point is denied. Zhenfeng Zhang versus Kelly Ruddick.
Ready, Your Honor. Good afternoon.
Good afternoon.
Eric Naslin, 42648, appearing on behalf of the plaintiffs.
Hi, Your Honor. My name is Kelly Reddock.
All right. And where are we on this case?
Well, I spoke to the defendant and my clients, and I believe we have a consent judgment. I was just writing it up. If she's willing to sign it, we're changing the writ date to February 15th of 26, which gives her a little bit of extra time to remain in the property. She does agree that she owes the back rent.
Is that correct, ma'am?
Yes.
You agree you owe it?
Yes.
All right. And the 15th, I mean, are you looking for additional time to find someplace or you're going to try to get this paid?
And then find someplace, Your Honor.
Okay. That's really what the intent here is. All right. Let me ask you this then. Is that going to be enough time for you? Because I think if I'm calling correctly, and maybe my memory is failing, you had a little one. You have it 8 years old?
Right. That's correct.
See, I told you I could.
Judge, you ought to get on Jeopardy with that memory.
No, Jeopardy is the.
That's pretty good at our age.
Yes, indeed. All right. And so let me ask you this. And I'm not trying to upset the deal that the folks have come to. Are you going to relax? All right. It's okay. Is that going to be enough time for you or?
I hope so. I don't know. As much time as I could get is great, but I appreciate them extending it to that point because I know that's not something they have to do or you have to do.
Okay, let me ask this.
Okay.
Your little one is in school?
Yes. Your Honor.
Second?
Third grade.
Third grade. It's been a while for me with little ones. His life's going to be upset anyway, right?
Hmm?
Do you have funds at all to try to do anything?
Yeah. Yes, Your Honor.
Okay, so what I was just wondering, I don't know if there's if she could pay a little bit of something and try to get to, I guess they have midwinter breaks or whatever. I just don't want the child's schooling interrupted if we can help it. But I don't know. Again, I'm not trying to upset the arrangement. I just, do you know when that is?
The break.
Yeah.
The calendar. It's in February.
Yeah, that's what I
It's the
thought.
weekend of the 5th. Oh, I believe it's the 16th, like the 16th through the 20th.
16th through the 20th is the
I
break.
believe so.
Okay, so maybe we hit this about right then. Okay. Because there's going to be a lot of adjustment there, right?
Yeah, you're right.
The 15th is a Sunday.
And so nothing would happen. 15th is a Sunday. There's a holiday, so you can't do anything. And so the 17th is the earliest that they could act.
that
So
we could get a writ, yeah.
yeah. So, and then that's going to take a little bit of time, but at least if you're going that week,
I can put the 17th on it because that's the first court date.
Can we do this? Can we give her to the 20th? That way she has that week clear that the child is out to do what she needs to do. And then if you need to get a writ, you can get a writ.
Yeah.
Well, you don't have to. I mean, I just have to be available to sign it.
It's already 8 months
Pardon?
without any payment. 8 months without any,
I'm asking for 4 days.
I know. As a landlord, I, sacrifice 8 months payment.
4 days.
Okay.
Okay.
Thank you.
And
All right. So you read that over. Do you agree with, you understand what you're signing there?
I believe so.
Did you want to take some time? I mean, I can pass it briefly and let you look it over and read it carefully. You want me to do that for you?
I believe the attorney, I believe he explained to me the document satisfactory.
Okay.
That I have until the 17th now, right? The 20th
20th now.
Yes.
Okay, to vacate the premises.
Vacate or pay the amount by the.
Or pay the amount by that time.
Correct.
If you pay the amount by that time, you could stay. If you
Got it.
don't pay the amount, you got to be out by that time.
Okay.
If I may, Your Honor, just take a second. The past due rent amount is $26,400. There's an additional $817.93, which is a water bill. So it's, as it stands, it's $27,217.93. I didn't add a filing fee or an attorney fee because the amount is such, it doesn't really make a lot of difference. And I did explain, and maybe I didn't, but there's a 3 business day right to rescind, which I put as January 21st. You could write a letter to the court and say that you wanted them to reconsider or set this aside. You would have to have a good cause, something beyond a change of mind or change of heart, just something that the court could consider within that time period. And they would look at this again in our agreement today.
Okay. I understand this then.
You understand that?
Yeah.
We're both Michigan grads. We sort of bonded in the hallway over.
University of Michigan?
Yes.
Sorry to hear that. I'm a Maryland grad, so we don't, that's the real U of M to me.
Go just for you, Judge. Go Terps.
There we go. Now we're talking.
But as long as you didn't say Ohio State, we're good.
No.
We can mutually dislike them.
That's it. Exactly.
But anyway.
Sure.
Okay, you understand that, ma'am?
Yes, Your Honor.
Okay.
I don't know where to sign.
It's down at the bottom. There's a little box down there that say defendant.
Well, it's defendant. You're representing yourself.
2 cases, 2 realities.
Sorry.
One defendant fighting to rebuild family contact, and another facing eviction after months of unpaid rent. The courtroom isn't just about guilt or innocence. It's about consequences, responsibility, and second chances. What would you have ruled if you were the judge?